Welcome to our webinar on what every lawyer should know about insurance coverage. My name is Nicole King. I'm an attorney in Venable's Los Angeles office. I practice in the commercial litigation group, as well as the insurance coverage and dispute group. Just to tell you a little bit about the firm, Venable is a full-service Am Law 100 law firm with 10 offices and over 850 attorneys in the United States. Venable's insurance coverage team consists of highly skilled attorneys who are committed to helping our clients to obtain insurance coverage, whether that's through litigation, mediation, arbitration, or settlement. We represent policyholders across all jurisdictions and industries nationwide. For the next hour, my colleague, John Warden, and I will be discussing a range of topics that all lawyers typically face in the context of insurance recovery. Specifically, we will be discussing the 11 topics that are outlined on your screen right now. While reviewing the topics, please remember that John and I are not giving legal advice today. Our discussion is rooted in our experience and expertise that we've gathered over the years in our practice. But during the program, please note that you can ask us questions through the chat box function or the Q&A function at the bottom of your screen. And also, we will make the slideshow available to you after the program is completed. John, will you tell everyone a little bit about yourself and get us into our first topic?
Thanks, Nicole. Yes, I'm John Warden. I'm a partner in the San Francisco office. I'm a trial lawyer. I've tried dozens of cases throughout the nation, although I'm primarily admitted in California and Nevada. Many of those cases have involved insurance issues. Indeed, every lawyer encounters insurance issues, whether they realize it or not. Whether you're a litigator, there's always someone who has insurance, should have insurance, was supposed to contract around getting insurance, etc. Transactional lawyers, we'll talk about this in a while. Transactional lawyers need to take account of who gets the insurance, who has to buy insurance, etc. Now, there are entire classes that are taught on this. I teach at UC Hastings Law School, and we cannot possibly in the next hour go over everything that could be taught about insurance law. Today's hour is focusing on spotting issues for those people who did not consider themselves insurance coverage experts. If you want to put a positive spin on it, a nice way to look at it is we will never be a bigger hero than when we tell our client, our company, what have you, a big lawsuit just came in, big dollars, big problems, but don't worry, I looked at the insurance, somebody else is going to pay for everything. You want to look at it from a more ominous perspective, it is malpractice to miss insurance coverage issues, even if you have not been asked to do so and you are not a coverage lawyer. Several years ago, the California Supreme Court had a case involving Jordache Jeans. Jordache had hired a very prominent law firm in California to defend class actions for many years. Several years into the litigation, Jordache changed firms after spending $50 million in defense costs to that point. The second firm started nosing around and figured out there would have been insurance coverage to cover the defense costs by the first firm, but they had not been tendered or given notice to the insurance company, and thus it was too late. Jordache sued the first firm, even though it never told the first firm it had insurance, didn't ask the first firm to analyze the insurance, and certainly never paid the first firm to look at the insurance issues. The California Supreme Court resolved the case on statute of limitations grounds, but held in dicta that had it been otherwise, the first firm could have committed malpractice by not giving notice to the insurance carriers the client never told them it had. When that came down, I was managing partner of our office at the time, and I immediately put on everyone's calendar a ticker that said a month after every new litigation matter must discuss insurance with client. One way or another, look at the insurance issues, even if the client never told us there were any insurance issues to be involved. So anyway, either way, insurance I find to be very fun. Why? There are answers. Some kinds of law, there just aren't answers. What's reasonable under the circumstances? All insurance policies, by and large, are exactly the same. My auto policy with State Farm is exactly the same as everyone else's auto policy with State Farm, which is exactly the same as everybody else's auto policy. What does that mean? It means if there's a dispute or an issue or something that needs to be analyzed, dozens, if not thousands, of appellate courts throughout the nation have already analyzed that exact issue. So Nicole and I are going to walk through what a lot of the answers are. Keep in mind, though, if you have one of those manuscript policies, as they call it, that's been specifically drafted just for you, well, contracts, insurance contracts are contracts just like other contracts. If your language is different than everybody else's policy, the answers we give might not be the same. But keep that in mind. Secondly, here's something that I find very fun about insurance law. It's the only area of law that I know of where the law is governed exclusively by state law, but the states analyze it completely different in some areas. Next, please. Just because my state says I have no coverage, the state next door might give me 100% coverage. Now, you can't just pick any state you want, but you can pick several states usually. The law could be the law of the state where the parties contracted it, where the insured signed the contract, where the insurer signed the contract, where the underlying injury took place, where the litigation is pending. All of those could potentially apply and they could all be different. So sometimes these issues are won or lost based on who gets to the courthouse first. And I'm going to give some examples of that later in the day. So the point is, if it comes in and you see something that looks like an insurance issue, look at it quickly, grab your colleague down the hall or get on the phone with your coverage counsel friend and have someone look at it soon, because it can make all the difference. Next, please. I'm not going to go through every possible difference. In some states, transaction lawyers, when you're entering into a merger or an acquisition or other transaction, most states, liabilities follow the assets. Therefore, most states conclude insurance follows the assets, but not in California. In California, insurance does not follow to the successor, except in very limited circumstances. Whereas in other states, it's the opposite. So if you're a transactional lawyer, you want to stay away from these areas, look at it at the time of the transaction. Next. Some states, well, punitive damages are almost never covered because intentional torts are almost never covered. However, some states, you can get coverage if the punitive damages are imposed based on some sort of respondeat superior or secondary liability theory. But some other states, it's the exact opposite. Next. Some states cover discrimination claims, some don't. Next. In some states, you can actually sue your adversary's insurance company directly. And in many states, you cannot. So the point is, every state is different. Look at it early. Be the first one to the courthouse if there's a strategic reason to do so. Nicole? We appear to be having technical difficulties with our sound.
Oh. Okay, so let me fix that for us.
Take the plates off. We
Mets. 6 runs in the bottom of an 8th.
I gotta see this game. If it wasn't for this guy, we could get out of here.
Traffic's a killer, ain't it?
You wanna get out of here? Here's what we do. We leave the car here. We take the plates off. We scratch the serial number off the engine block and we walk away. Walk away? You've got insurance. You tell them that the car was stolen and then you get another one free.
Isn't there a deductible?
All right, what is your deductible?
I don't know.
Yes, because they've already deducted it.
From what?
The car, which we're leaving. So the net is 0. See, you pocket the money, if there is any, and you get a new car.
We're not leaving the car.
All right. If you refuse to grow up and scam your insurance company, you'll have to work this out with Maroon Golf.
So Kramer's idea for scamming the insurance company is not endorsed by Venable, but we can appreciate that Kramer understood the type of insurance policy that Jerry had in great detail to ensure that Jerry would get all the benefits from the insurance policy from the provisions that Jerry had been investing in. And that's what we encourage all lawyers to do on behalf of their clients. And when we're thinking about the type of insurance policies available to our clients, we're generally talking about insurance policies that fall into two categories: first-party policies versus third-party policies. When we think about first-party policies, all we need to know is that these type of policies cover policyholders themselves or policyholders' property. Some policies that come to mind, for example, are automobile insurance policies, medical insurance policies, homeowners insurance policies, or personal or business property insurance policies. With respect to third-party policies, these policies protect the insured against claims that are brought by third parties. Now, third-party policies are the typical policies that I handle in pursuing insurance coverage on behalf of our clients. Typically, the policies include comprehensive general liability policies, directors and officers insurance policy, employee practice liability insurance policy, errors and omissions insurance policy, as well as professional liability insurance policies. In addition to understanding the type of insurance policies available to our clients, it's also important to understand whether the policy is a claims-made policy versus an occurrence-based policy. Now, these two components with respect to the insurance policies are important because they dictate when exactly insurance coverage kicks in. So it's important to know how they work. When we think about claims-made policies, all we need to know is that coverage is applicable to a claim if a claim is made during the policy period or when the policyholder had active insurance. And I keep on talking about the term claim, so I think it's important here that we define it. As a number one rule, when we are trying to define a term or a phrase or trying to get direction of a procedure in terms of insurance coverage, always refer to the policy. The policy language will naturally and almost always will dictate. But although the term specifically for claim varies depending on the policy language, we can at least know that it will include, for example, a written demand for monetary relief or non-monetary relief, a formal civil proceeding that has been filed against your client. It can be an administrative or regulatory proceeding, or it could be any written notice describing circumstances that will likely lead to a civil proceeding. I recently handled a wrongful death case where this came into play. So it was a wrongful death case that I was handling on behalf of our clients. The incident happened on rental property that our clients owned. And at the time, the property was going to be sold within a 2-week span to new owners. So the claimant's attorney sent our client a notice of preservation of evidence letter, which basically just said, okay, we're gonna conduct an on-site investigation on the property. We're also going to gather evidence from the property and the surrounding area before the property is actually sold to new owners. And in that instance, under those circumstances, the notice of preservation of evidence letter was the claim. And that's what we gave the insurance company to actually trigger coverage. So in contrast to claims-made policies, we have occurrence-based policies. And all we need to remember when we talk about occurrence-based policies is that coverage covers or kicks in if the incident or the occurrence happened during the policy period. And it's regardless when the claim was actually made by the third party. In assessing the appropriate type of insurance policy and the appropriate components, Naturally, it's important to note that occurrence-based policies are pricier and more expensive than a claims-made policy because of the broad application of coverage and how long coverage lasts. So in sum, our clients can never have enough insurance. But I think it's important to understand that insurance policies are not issued on one form across the board within the entire insurance industry. They're subject to negotiation. So it's important for our clients to understand the appropriate insurance policy that's applicable to them. It's also important that they are actually getting the coverage that they deserve from the provisions that they have been investing in all along. John, will you provide more information on the topic of occurrences?
Yes, so lawsuit comes in, claim comes in, and you look at your current policy for January 2021, and it has an exclusion. So that's it, you're out of luck, right? Not at all. As Nicole said, there are lots of different kinds of policies out there. Some that cover claims made today, some that cover claims made long ago if the injury occurred then. So if somebody slips on a banana peel, gets in a car accident, there's an explosion, the occurrence is obviously when that finite event took place. But the real world of litigation is much more complicated. Next, please. What happens if someone breathes in asbestos in the 1950s and gets sick a few years ago and dies last year and the family files a lawsuit today? Is it the first policy in the 1950s, the policy when they got sick, the policy when they filed suit? What about a case involving TCE that gets kicked into the water supply somehow and years later causes children to get leukemia? What about a case I had where a building in San Diego is constructed 20 years ago and slowly moves an inch or two every year down a hillside until it hits the building next to it? These are big deal cases. Which policies apply? Under the continuous trigger analysis, which I'll talk about now, potentially all of them, from the beginning, when the person first breathed in that asbestos, or the TCE was first released, or the building first started moving, until now. As it says here, an occurrence-based policy is triggered if property damage or bodily injury occur during the policy period. Next, please. Generally, when the bad act took place, makes no difference at all. Next, please. In 1995, the California Supreme Court issued the Montrose II decision, the case of Montrose versus Admiral. There's lots of Montrose decisions. It's basically the same case, kept going back and forth up and down to the California Supreme Court. In Montrose II, now followed by virtually every jurisdiction, it was an environmental case, and the court held that a continuous trigger should be adopted in all third-party cases involving continuous or deteriorating losses. Next, please. All different areas we're litigating involve these issues. Asbestos. Now, you think asbestos isn't a big deal? The judicial hellhole list for top 10 judicial hellholes just came out, and California made the top 3 again, as usual. However, 7 of the top 10, whether it be Philadelphia, New York, South Carolina, Oklahoma, there were some surprises on the list. Almost all of them are there because of their asbestos docket, in whole or in part. It's still a big deal. And which insurance policies, to the extent anybody has insurance left, which ones are defending those cases? Not the 2021 policies that have excluded asbestos for years. It's the policies back in the 50s and 60s that had no exclusions, low deductibles, if any deductibles, low aggregate limits, high aggregate limits or no aggregate limits, meaning they just go and go and go, no matter how many claims there are. Other cases, environmental, soil subsidence, rot, corrosion, leakage, all kinds of construction cases. All of these involve this analysis. So when that case comes in, just because your current policy today doesn't cover it, all is not lost. Next, I should add though, that because the insurance companies didn't like the way the Montrose 2 continuous trigger was applying, most of the later policies have a continuous injury exclusion, sometimes colloquially referred to as a Montrose 2 exclusion. But that's for the new ones, not for the old ones. Next, please. Another big deal in insurance coverage these days is how many occurrences there are. If somebody slips in that banana peel, gets in that car accident, it's one occurrence. It's very simple. Well, the real world is more complicated. Next, please. What about a case, a construction project, where the architect designs everyone's foundation slab the same for all 100 houses in the subdivision, and 50 of them start cracking years after the fact? Is it 50 occurrences, one occurrence, or otherwise? Next, please. What difference does it make? Most policies have deductibles per occurrence. Most policies have limits these days per occurrence. So if every one of those houses needs $50,000 of repairs and each occurrence has a $100,000 deductible, there's not going to be any coverage. This is an issue that is debated dramatically between carriers and policyholders, and it's not one of these cases where all the carriers are on one side and all the policyholders are on the other. Kind of depends how the math adds up. Next, please. As a general rule, if there's one cause that causes all of the different damages, regardless of how many people are involved, properties are involved, lawsuits are involved, it's considered one occurrence. There are states that look at it differently. And let me give you a concrete example of how this plays out in the real world. 9/11, World Trade Center collision, terrorist attack. 2 planes hit 2 buildings at 2 different times with 2 different groups of terrorists hijacking each. The owners of the World Trade Center had $3.5 billion of insurance coverage per occurrence. So do they have 3.5 million? Or do they have 3.5 billion with a B, or 7 billion? The arguments were 2 different planes, 2 different towers, 2 different collapses, 2 occurrences, 7 billion. The other argument is, obviously, this was a coordinated attack. These terrorists weren't acting independently of each other. 1 occurrence. Just to show how this plays out, because there were different insurers involved, these were tried in front of different jurors, and some juries found 1 occurrence and some found 2. But it's a big deal to look at the beginning when the claim comes in. Maybe you don't have $7 billion at issue, but whatever you have at issue, it could be a big deal in your circumstance. Next, please.
So now we're going to talk a little bit about the tender of defense. And with the within the context of insurance coverage, what tender is just the transmission of information to the insurance carrier. And you're basically describing the contents or the substance of a claim that's been brought against your client by a third party. And by tendering the defense of a claim, what we're asking the insurance carrier to do is not only to, 1, provide a defense, but also to provide defense costs and control the claim, meaning controlling the litigation as well as settlement. If there's one thing that you should remember that I say today on the topic of tendering, is to tender as soon as possible. And when I say tender as soon as possible, I just mean, based on the circumstances of your case, please tender promptly and reasonably to the insurance carrier. And also, when you're tendering, remember to not only tender claims that you know are covered under your insurance policy, but you want to tender claims that are potentially covered under the insurance policy. So why tender early? So tendering early can mean the difference between your client paying hundreds and hundreds of thousands of dollars in litigation fees versus the insurance carrier picking up that tab. Now, the insurance carrier is, has a duty to defend or has a right to defend a claim that's been brought against an insured by a third party, but is not obligated to undertake that duty unless it's asked. So why not ask the insurance carrier as soon as possible? Additionally, if you provide late notice to the insurance carrier, there is a possibility that your claim will be denied. It's not an absolute bar to coverage because it will, it differs from state to state and from policy to policy. But as a rule of thumb, I would just tender as soon as possible. But John, can you give an example of when late notice had a negative impact on one of your cases?
Sure. I've had a lot of late notice issues, and there are some people who believe you should pick and choose when to tender because insurance companies keep track of how many times you tender. If you tender every little thing, your rates go up. The ones I see suggest a very completely different perspective. The ones I see are the ones that have catastrophic circumstances if someone doesn't tender. As we've already discussed, pre-tender defense costs are almost never recoverable in any state. So all those Jordache jeans defense costs are out the window. However, jury verdicts and settlements can be recoverable. Let me give you an example. So I tried a case in federal court in the Midwest a few years ago. And in that case, there was an underlying case where a physician at a hospital that our client owned in Indiana slipped and fell in a puddle and hurt his elbow. He already had a pre-existing elbow injury. It wasn't that big of a deal. And the particular county had never had a jury verdict in a personal injury case over $1 million. And our client had $1 million deductible in that case. So nobody ever told the insurance company until the verdict came down awarding the surgeon $16 million. The next day I get a call. Are we out of luck? Definitely out of luck for the defense costs. However, some states, if you tender after the fact, if you tender late, you're completely out of luck. But in some states, the carrier has to prove they were prejudiced. We raced to the courthouse in this state in the Midwest. And after a 2-week trial, the jury did award us $15 million, $16 million minus the $1 million deductible because the carrier did not meet their burden of proving they had been prejudiced. However, all of this could have been alleviated if someone had given notice. It was a lot of aggravation and somebody got fired, all of which I would have never heard about it if they had just tendered the claim. That's just one example.
Well, thanks, John. So in wrapping up tendering is not difficult. But like I said before, a number one rule for direction in terms of insurance coverage, always refer to the policy. So refer to the policy for direction on how to tender. But we can at least consider that tendering to the insurance carrier requires that the insured provides information regarding the name of the insured, policy information. You have to give a copy of a summons or a complaint or any other related pleading, the date of service, or any correspondence from a plaintiff, counsel, or other party. And, the notice of preservation of evidence that I mentioned earlier fits into this category. So now we're going to play a video of a typical dialogue that happens after an insured has tendered to the insurance carrier. And then John is going to lead us into our next topic.
I would like you to defend a case I just received. All right, can you tell me about it? We don't want to pay anything. Can you be more specific? No more than $0. I mean, can you tell me something more specific about the facts of the case? The fact is that you should not pay any money to the plaintiff. All right. Other than that, is there anything I should know? Yes. Do not do any work on the case, either. Why not? Because I do not want to pay you either. How am I supposed to defend the case? You should contact me at each critical stage of the case and get approval to take action to defend the case. Can you tell me what is a critical stage? Yes. Everything is a critical stage. So I should call you and let you decide each time I want to send a letter or make a phone call. Yes. and you will approve those things. I probably will not. Then how am I supposed to defend this case? Do your best. What if I forget to get your approval and accidentally make a phone call to the attorney for the other side? I will not pay you for your time. What if it advances the case? It was not approved. You do understand that attorneys do not work for free, correct? I understand the problems of our system. But I cannot work for free and still pay my bills. If you do not, then I will call your boss and complain to him. About what? About you not defending this case. How am I supposed to defend this case? That's not my problem. When you do approve an action, are you going to pay for it? No. You are supposed to write those off as a customer service incentive for me to send you more cases. Let me try to understand. You want me to defend this case, but will not approve spending any money for it. When you do approve an expense, you want me to write it off, because I want you to send me more cases that you will not pay for. I'm glad we have an agreement.
Yes, so most insurance carriers are a little easier to deal with than that, just like most policyholders are a little more honest than Kramer. But the biggest dispute between carriers and policyholders has to do with the duty to defend. It is the issue that has related in exceptional amounts of litigation over the years. It is the tail that wags the dog. Next, please. Many cases involve a very, very broad duty to defend a case. However, that's not always the case. And so just as a cautionary tale, sometimes I have conversations with clients where they get sued for something that's not covered, not even potentially covered. And they say, wait a minute, I got sued. Isn't that why I have insurance? Well, there's really no such thing as litigation insurance. It has to be something that is addressed in one of the policies. For example, I do a lot of work in Nevada. I've had a lot of casino construction cases, and they're always delayed, and there's always a lawsuit after that. There was no property damage, no personal injury. Nobody got hurt. Just a lot of money at stake because it was late. What about a case, the old law school exam question, where the house was supposed to be built with brass pipes and it was built with copper pipes? Do they have to tear the whole house down and repair it? Either way, it's going to be big money, and either way, it's probably not going to be covered, and therefore probably no duty to defend because there's no property damage or personal injury. And that's usually the key. Next. But where there is any allegation of that, a very broad duty attaches. This provision right here, I may say, is the most litigated provision, the most litigated sentence in all of American jurisprudence. We, the carrier, have the right and duty to defend any suit. Well, what is a suit? We'll talk about that. Seeking damages. What are damages? For bodily injury and property damage to which this insurance applies. Next. So if there's an allegation of property damage and personal injury caused by negligent as opposed to intentional conduct, even if the claim is clearly false, fraudulent, made up, there's still going to be a duty to defend the case and a duty to defend the entire case, all the claims, almost assuredly until the end. Next. So I talked about Montrose 2, the first Montrose decision, probably the most cited insurance coverage decision out there, the 1993 California Supreme Court case of Montrose 1. The arguments were, well, we only have to defend the case if most of the claims are covered or all the claims are covered. No. The California Supreme Court held, and virtually everyone has now followed it, that if there is any conceivable theory which could provide for coverage, the carrier has the duty to defend. Next. And that's based on not just the complaint, anything in the complaint, but other information that's available. Next, please. And this goes from the beginning of the case until the end with very rare circumstances. Let me give you an example of a real case, how this plays out. So I represented this company in a business dispute. Our star witness was an engineer who I got to know very well. We'll call him Tyson. Tyson I really liked. Very soft-spoken, very professional, great witness. That case ends, life goes on. A year later, I get a call from Tyson, and he told me he had just been sued. It seems that he and his friend Sloan were at a lunch counter in downtown San Francisco, and a woman cut in front of Sloan. Tyson said, "No, excuse me, you're cutting, you have to go to the end of the line." She became very belligerent, started pushing him, and he hauled off and punched her in the face. He was the most soft-spoken gentleman. I couldn't believe he did it. He told me he had never punched anyone in his life, which I found hard to believe. You never punched your brother. You never punched somebody on the playground. He said, that's right. That's the first punch he'd ever thrown. Well, Tyson could have been a professional prize fighter because the one punch, the only punch he ever threw in his life, cost over $100,000 in medical bills and plastic surgery to reconstruct the plaintiff's face. So Tyson realizes, as is obvious to all of us, he made a big mistake. He's got a real problem here. The lawsuit had two causes of action, one for civil intentional assault, okay? The other was for negligently touching the plaintiff's face, causing personal injury. Now, I don't even know how you could negligently punch somebody in the face, some sort of an arm spasm. I don't even know how it's conceivable. However, that's what they alleged. And I never asked the plaintiff's lawyer this, but I guarantee you the reason it was there was they were pleading into coverage, as they say. They put that claim in there to trigger Tyson's homeowner's policy. And it did. Because of the negligence claim, alleging personal injury, his homeowner's policy paid our defense costs and paid for a substantial portion of the damages. Speaking of which, we have a question which is related to that, and I'll read the question right now. Please address the insurance-related difficulties faced by nonprofit schools where sexual abuse is alleged from many years ago, and schools cannot locate insurance policies or are confronted with refusals by insurers to cover the claim. Well, again, it depends what the policy is. A lot of these things are excluded now. However, I had a case just like this in another Midwest state where one of our orderlies raped a mentally challenged patient. They did the same thing. They alleged rape. They also alleged negligent touching, which I guarantee was to trigger the insurance coverage in our policy. And the carrier did step in and did pay for at least some of the freight. Your other point, when they can't find the policies, you don't have to have a policy. It seems counterintuitive. You had to at some point have a policy, but the California Supreme Court in the Dart Industries case, and there are lots of other states have this exact same standard. If you can show evidence, you've got to have something showing we used to have coverage, letters back and forth with the agent or broker, which would have covered this. That can be sufficient to trigger that duty. Anyway, Nicole, let's say the policyholder and the carrier have a dispute over the defense. What happens then?
Sure, John. So the insurance company controls the defense of a claim absent a conflict of interest. But it's also important to know that the concept of conflict of interest is not static or concrete on the day that the claim is tendered to the insurance company. After an insured tenders the defense of a claim to the insurance company, generally the insurance company responds in one of two ways. The insurance company will either deny coverage outright, or the insurance company will accept its duty to defend, but under a reservation of right to deny coverage later. I want to talk a little bit more about what it means for an insurance company to defend under a reservation of right. So when an insurance company takes the position of defending under a reservation of rights, typically we receive a letter from the insurance company, and the insurance company basically just lists out potential coverage issues that if the outcome turns in favor of non-coverage, the insurance company will use that as a basis to later deny coverage of the claim, which results in a conflict of interest, excuse me. So generally, when we receive that reservation of rights letter, as attorneys, we typically view them as non-existent or theoretical conflicts of interest. But there are some potential coverage issues that we do have to pay attention to. And those potential coverage issues that we pay attention to is if we have decided that the outcome of the potential coverage issue can be controlled by the insurance company, disfavoring the interest of the insured. And so let me give you an example of that. Sometimes we come across comprehensive general liability insurance policies. And in those policies, there are express exclusions that exclude coverage or deny coverage if the insured has acted intentionally or recklessly. And at that point, the insurance company is trying to gather evidence to prove that the insured is acting recklessly or intentionally with regard to a claim in order to use that as a basis to deny coverage. And so that is an issue where we recognize that the outcome can be controlled by the insurance company. And then we also recognize that it's a direct conflict of interest because on the other end, the insured is trying to gather evidence to dispute the insurance company and basically support the position that they haven't acted intentionally or recklessly and that coverage should apply. And under those circumstances, when we see that potential coverage issue that the outcome can be controlled by the insurance carrier, the insured can now invoke its right to independent counsel, or what is known as cumulus counsel, and the concept of insurance recovery. And the insured is entitled to independent counsel at the expense of the insurance carrier. Other examples that entitle the insured to independent counsel or cumulus counsel include when the insurance company files a suit against the insured, the insurance company insures opposing parties in a lawsuit, or the insurance company pursues settlement in excess of the policy limits without the insured's consent. John, will you go into what is a suit?
Yes, first I'm reminded I'm supposed to announce that if you want CLE credit, there's a code you have to enter, and that code is Insurance 2021. Insurance 2121. What is a suit? So this becomes an issue. Well, that provision that I read a little while ago, next please. It says that the carrier shall have the right and duty to defend any suit. Next please. So what is a suit? If somebody sends a settlement demand letter, is that a suit? Does an arbitration count as a suit? A governmental administrative action. If the EPA sues in an administrative action, is that a suit? It's pretty serious. You can't ignore it. So do these count? Well, next, please. In most states, the duty to defend does not hinge on the technical form of the threat. It's merely the fact that there is an actual or threatened use of legal process to coerce payment by the policyholder. Next. Of course, California has to do everything different. So in California, in our California Supreme Court case on this issue, a suit means a lawsuit, a suit filed in Superior Court or federal court. So again, this is one of those areas, look at it closely at the beginning to determine whether what is happening to you is going to be covered or not. So let's take an example, settlement demand. Settlement demand comes in, it can be certainly a malpractice trap to settle cases without telling the carrier until later. I talked about the late notice before. There's also a provision in every insurance policy just about that says you cannot make voluntary payments. So whatever comes in, arbitration, settlement demand, or otherwise, look at the insurance, tender it. If the carrier denies the tender, you can do almost anything you want thereafter and you still have rights vis-a-vis the carrier. If you never give them notice, you end up with that problem I had with the surgeon who slipped and fell. Nicole, we have a question that relates to, I think, what you're going to hit next. It says, in the examples you provide where plaintiffs use the negligence claim, isn't there an allocation clause that may result in no payment because of negligence? So as I mentioned, there's not an allocation to defense costs generally, although there's a case that, and I think Nicole will talk about in a moment, where the carrier could make an issue, but there's definitely allocation when it comes to settlements or judgments. Nicole?
Yes. So when we talk about allocation, and we'll touch upon this, hopefully we give an answer to the question that we just received. When we talk about allocation, generally our clients are faced with lawsuits that are claiming damages and injuries that some are covered under the insurance policy and some are not. And so insurance companies use the basis of allocation or to deny coverage of what they deem are claims that are not covered under the insurance policy or that exceed the limits of the insurance policy. But generally, courts take the view that so long as there's just one claim that can be potentially covered in the lawsuit, that the insurance carrier has a duty to cover the defense of all of the claims. So what that means is covered claims do not have to dominate the lawsuit. The lawsuit just has to have one or some potential for liability against the insured for the insurance company to invoke its duty to defend the entire lawsuit. So we've been talking a lot about the duty to defend and its broad coverage. As we explained, the duty to defend applies to not only covered claims, but also to potentially covered claims. But I want to switch gears a little bit to talk about the duty to indemnify, which is narrower in scope. When we think about the duty to indemnify, all that means is that the insurance carrier has the duty or obligation to pay costs of judgment and settlement that's resulting in a claim that's been brought against our client as the insured by a third party. But the duty to indemnify is only triggered when liability is established, as well as it only runs to covered claims. So let's talk about an example. So let's say we have a case, another mixed bag of claims. We have a negligence claim and a fraud claim. This lawsuit goes to trial and a jury finds negligence but not fraud. So the duty to indemnify the policyholder for the cost of judgment is triggered under the judgment that's the finding of negligence but not fraud, because liability is actually established under the negligence claim, not the fraud claim, and then the judgment is based solely on the covered cause of action, which is negligence. Now, when we think about the duty to indemnify as it relates to settlement, there are a couple of things that we should consider. First, on behalf of our clients, the number one rule is do not settle a lawsuit without the insurance company's consent. Generally, an insurance company is not obligated to accept every settlement offer that comes its way. So while an insurance company is obligated to indemnify an insured or a policyholder, the insurance company doesn't have to do so if it did not consent to settlement beforehand. However, although an insurance company doesn't have to accept every settlement offer, what the insurance company does have to do is to evaluate the reasonableness of a settlement offer by considering whether a likely judgment will exceed the cost or the amount of the policy limit. And how we get the insurance company to do that, we provide an analysis of the extent of the injuries and damages that are brought against our clients. We talk about the evidence related to the insured's liability. We assess the merits of the case, and we provide examples of jury verdicts rendered in similar cases. This actually came up in one of my cases. We were handling a case on behalf of clients who were facing a class action lawsuit. And we quickly realized that based on the merits of the case, we were not going to be able to get our clients out of the litigation early on motion practice, for example, on a motion to dismiss. So in terms of our strategy, we determined that early resolution was probably in the best interest of our client, but also in the best interest of the insurance company. And we had been receiving multiple rounds of settlement offers from plaintiff's counsel. And every time we brought the settlement offers to the insurance company denied it based on its right to deny settlement offers because it's not obligated to accept. So we thought, how are we going to get the insurance company to the table so that they can really consider the settlement offers and consider the reasonableness of the offers? And so what we did was we provided an analysis to the insurance company. We analyzed the claims and damages brought against our client. We assessed the merits of the case. We provided analysis of the likely judgment against our client and the cost. And then we also provided examples of judgments that were entered in similar cases to show that the likely judgment that was going to be entered against our client would exceed the policy limit of the insurance policy at issue. And we were actually successful. We got the insurance company to agree to settle the case, and it was the best outcome for our client, but also for the insurance company. So the last topic that I'm going to share during this webinar today is the basis of exclusions. So exclusions are basically express provisions in insurance policies that insurance carriers rely on to deny or limit coverage. Standard exclusion provisions vary depending on the policy, but it is the insurance carrier's burden to show that an exclusion provision is applicable. It's also the insurance carrier's burden to show that an exclusion is consistent with applicable or controlling law or consistent with public policy. And naturally, because of the nature of exclusions, they are construed narrowly in favor of coverage. Typical exclusion provisions that come up in our practice, for example, when we are assessing comprehensive general liability policies, exclusions may come up where coverage is excluded for property owned, operated, and leased by the policyholder. When we're thinking about directors and officers policies, provisions may exclude coverage for illegal personal gain, short wing profits, and claims that should be covered by other available insurance. And then we have prior wrongful or prior knowledge exclusions. And these exclusions typically exclude coverage of alleged conduct that happened before the effective date of a policy. John, will you talk about how COVID-19 has impacted insurance recovery this year? John, you're on mute.
We just saw that huffing and puffing is not covered, but what if the person huffing and puffing is positive for COVID? We couldn't conclude a seminar on insurance in 2021 without discussing COVID, at least briefly. In the last 10 months, there have been 6,900 lawsuits filed relating to COVID. 1,400 of them, 20% of all COVID-related lawsuits have been coverage cases. Next, please. Now, unfortunately, I said there are lots of answers. I don't have a lot of answers yet for this because there's been very little, if any, appellate authority. Most of the claims fall under the business interruption coverage or claims because a subset of that is damages relating to a civil authority stepping in. Next, please. And the arguments opposed are generally, well, there's no property damage. You just can't get to the property, or you're prohibited from getting to the property. Sometimes there are virus exclusions too. A lot of insurers have filed motion to dismiss. They've won some. The policyholders have won some. Here at Venable, we are really at the forefront. I realize I'm biased, but we are at the forefront of the COVID area. We have a number of cases pending regarding COVID, and stay tuned. The appellate courts will start ruling on these soon enough, but there's very little appellate authority, but this is going to be a big, big area. Speaking of big areas though, Nicole, before we conclude, we have a couple more questions. One is, what about the issue of being issued a non-party subpoena, but the area of inquiry has a potential to bring you into the case? Should you send to the carriers? It's a provocative question. I'm going to take a wild guess. I've never tried to tender a third-party subpoena. Maybe I should think about that. But I think probably the answer is, since the third party, assuming they haven't been cross-complained against, they're just getting a subpoena, there's no damage claim. And most policies only provide a defense obligation to defend claims for damages. Nicole, have you seen that issue come up?
I have not seen that issue come up, but I do think that it may fall into the category of sort of a written notice, and the subpoena may provide or describe circumstances that will tip you off that a forthcoming civil proceeding will be filed. So it might be advantageous for you to let your insurance carrier know that you anticipate a claim will be filed, and I would tender that claim as soon as possible.
Okay, and we have one more question. What is the statute of limitations where a plaintiff tenders to the insurer, but the insurer wrongfully denies the duty to defend? Plaintiff then pays for the defense. Can the plaintiff now, after conclusion of litigation, make a claim against his or her insurer? So a lot of things going on in that question. As a general rule, the statute of limitations in coverage cases is the same as for breach of contract, because it's just another kind of contract in many ways. In California, that's 4 years from the breach. So that's one issue. Obviously, different states analyze this differently. Now, as far as indemnity claims generally do not accrue until the plaintiff pays money to someone. So that's a different statute of limitations. California, I think it's a year for indemnity, but I could be wrong about that. But Nicole, do you have any thoughts on this particular question?
No, I agree with you. And just reinforcing the indemnity claims, liability has to be established before the time is triggered.
Okay, that's all the questions. Thank you, Nicole.
Okay. Well, that's all, folks. We want to thank you for joining our webinar today. And if you have any questions, please feel free to contact John or myself. Here's our contact information. And also, if you need a copy of the slides, please feel free to contact us and we'll get them to you as soon as possible. Thanks again for joining.